This is Barry Zalma speaking for Claim School Incorporated with another True Crime of Insurance Fraud video. This one, video number 67, a story about why a policy obtained by fraud requires the insured to reimburse the insurer for its expenditures for defense and indemnity. Today I'm diverting from stories where I was personally involved. This story comes from the U.S. 10th Circuit Court of Appeal. An insurer asserted claims against its insured for fraud and unjust enrichment. The 10th Circuit was asked to determine if Colorado law permits an insurer to recover a settlement payment made on behalf of its insured for fraud. The insured fraudulently obtained an insurance policy for its inpatient-drug-treatment center, and when the insured was sued by a former patient, the insurer assumed the insured's defense subject to a reservation of rights. Even after learning that the insured had fraudulently obtained the policy, the insurer settled with the former patient under pressure from the insured and threats of bad faith litigation. The insurer sought to recover from its insured the settlement payment. In Evanston Insurance Company versus Insured Laboratories, a U.S. Court of Appeals for the 10th Circuit decision dated March 18, 2020, Insured Laboratories, a Colorado corporation, owned and operated an addiction treatment center in Lone Tree, Colorado. On October 19, 2014, Insured procured an insurance policy for the treatment center from Evanston Insurance Company. The policy covered outpatient drug alcohol rehab services. To secure the policy, Insured made several material misrepresentations and omissions. For example, Insured failed to disclose that it maintained overnight beds for its patients, instead claiming it operated its business solely between 10 a.m. and 5 p.m. Insured also falsely denied that any of its employees had ever been evaluated or treated for alcoholism or drug addiction, and misrepresented the circumstances by which its CEO had lost her chiropractic license. Brandon Lastly, a former Insured patient, sued Insured Dr. Jonathan Lee, its medical director, and Tamara Ray Cisco, Insured's CEO, in the District of Colorado. Evanston initially declined to provide a defense to Insured, concluding that the claims were outside the scope of coverage because they alleged intentional and fraudulent conduct. Lastly amended his complaint, adding several state claims against Insured and Dr. Lee for negligence and breach of fiduciary duty. Evanston, which again concluded that no coverage was afforded for the Lastly suit, but because of the amendment, Evanston accepted Insured's defense subject to a full reservation of rights, including the right to withdraw the defense and the right to pursue reimbursement from Insured, while it sought a declaration of its rights and duties under the policy. At a mediation, Insured's attorney, Jared West, pressured Evanston to pay the full $260,000 settlement amount demanded by the plaintiffs, Lastly, by threatening to bring a bad faith claim against Evanston. In the communications that followed, Evanston made clear to West that if it settled the case, it would seek reimbursement for the entire cost of defense and indemnity. Faced with the deadline and threat of bad faith litigation, Evanston agreed to fund the $260,000 settlement while reserving the right to seek full reimbursement from Insured. In a declaratory relief action filed before the payment, Evanston had sought a declaration that no defense or indemnity coverage was owed pursuant to Insured's insurance policy for the Lastly suit, and asserted unjust enrichment and sought recovery of litigation expenses and settlement payment in the Lastly case from Insured, Dr. Lee, and Cisco because the claims and damages were not covered or cannot be covered pursuant to Colorado law and public policy. The final two claims alleged that Insured and Cisco had made fraudulent misrepresentations and concealments in Insured's insurance policy application and sought damages for this fraud, including the settlement payment. Aminicat's lawyers withdrew and Aminicate failed to gain new counsel. The insurer in due course obtained a default against Aminicate, and the district court entered judgment that held Aminicate liable to reimburse Evanston for the settlement payment as damages for both fraud and unjust enrichment for $427,280.30. The settlement payment plus defense costs and an extra $77,000 for prejudgment interest. When challenging a default judgment, a defendant admits to a complaint's well-pleaded facts and forfeits his or her ability to contest those facts. But even in default, a defendant is not prohibited from challenging the legal sufficiency of the case. Under Colorado law, the defrauded party may recover such damages as are a natural and proximate consequence of the fraud. The damages must stem from the plaintiff's reliance on the fraud. To claim damages from the allegedly fraudulent statements, the plaintiff must establish detrimental reliance on the statements. Evidence established that Evanston would not have issued the policy had Aminicate disclosed or communicated the true facts of its operation. Aminicate argued that because Evanston knew of the fraud when it settled, it could not have relied on the fraud when it agreed to fund the settlement. Generally, a defrauded party cannot recover damages for the period after the victim discovers the fraud because he no longer has any basis for relying on the misrepresentations. But when the defrauded party discovers the fraud after substantial performance, or where it would be economically unreasonable to terminate the relationship, he may affirm or continue the contract and then bring suit for his entire damages. The 10th Circuit concluded that it would have been economically unreasonable for Evanston to refuse to pay the settlement because doing so would have placed Evanston at risk of a bad faith lawsuit and its insured of a verdict larger than the settlement amount if the case went to trial. An insurer owes its insured a duty of good faith and fair dealing. Violation of this duty can result in a bad faith claim against the insurer judged by a reasonableness standard. In this case, Evanston was rightfully concerned that a potential bad faith suit by Aminicate, given the threats made by its attorney, after Evanston originally balked at paying the settlement. After learning of the fraud, Evanston was in no position to abandon its defense without risking substantial liability, or at least incurring substantial litigation costs from defending a bad faith suit. Given these considerations, the 10th Circuit concluded that the settlement payment was a natural and proximate consequence of Aminicate's fraud. Colorado has adopted a general policy against insurance fraud, allowing insureds to receive the benefit of an insurance coverage even when they have fraudulently obtained it would foster, not deter, insurance fraud. It would signal to potential fraudsters that if they can convince their insurance company to settle via the threat of a bad faith lawsuit, they will benefit from their fraud. Such a result would not comport with Colorado public policy. Therefore, the 10th Circuit concluded that Evanston can recover the settlement payment made on behalf of Aminicate as fraud damages. Insurance fraud perpetrators should never be allowed to profit from their fraud. Since the policy was subject to rescission or voidance as a result of a blatant and admitted fraud, the insured had no right to defense or indemnity. However, since the fraud was not detected until after the insurer agreed to defend, subject to its reservation of rights, it had no good way to escape the obligation without facing a bad faith lawsuit seeking both contract and tort damages. The insured's threat forced the insurer to fund the settlement and seek reimbursement. The 10th Circuit enforced the right to reimbursement, and hopefully the defendants have sufficient funds to pay the judgment, since Indemnity did not respond to the insurer's suit and allowed a default judgment to be rendered. The chances of collecting the judgments may be slim. If an insurer is unable to collect the judgment, the fraud succeeded, and the insurer is left with a piece of paper called a judgment that it can do nothing with and gain no funds from. This video was adapted from my book, Insurance Fraud Cost Everyone, which is a supplement to my treatise in 2 volumes, Insurance Fraud 2nd Edition, all of which are available as Kindle books, paperbacks, and hardcovers from Amazon.com. Thank you for your attention.